Right. Today we are going to discuss about fundamental rights. Before going to discuss about the fundamental rights, let us try to understand the historical evolution of the and historical demands for the fundamental rights. The Indians' desires for civil rights had its roots in deep in 19th century. It was implicit in the formation of Indian National Congress in the year of 1885. 1885 was the establishment year of Indian National Congress, and after that a series of INC resolutions passed in between 1917 and 1919. In between these 2 years, number of resolutions adopted by the Indian National Congress, those resolutions repeatedly demanded for the civil rights and equality of status with Englishmen. And after Congress party passed a resolution in the year of 1927 which declared that the basis of future Indian constitution must be declaration of fundamental rights. This was the historical demands made by the Indian National Congress leaders regarding the fundamental rights. Right. Let us try to understand the definition of right. What is meant by right? Why they are called fundamental rights? Definition. A right which is claimed by individual and second one, that should be recognized by the state. Here state means government. The right should be recognized by the government, and third one, that should be accepted by the society. And finally, that should be enforceable by law. So if anything said to be right, it has to satisfy these conditions. Once we recall the conditions for a right is that should be claimed by individual and recognized by the state and accepted by the society and enforceable by the law, then only it's said to be a right. Now let us try to understand the features of fundamental rights. Before that one, why they are called fundamental? What is the reason for they are called as a fundamental rights? They are called as a fundamental rights because they are mentioned in the fundamental law of the land. Here fundamental law of the land means constitution. Constitution is also known as the fundamental law of the land. They are mentioned in the constitution, so that is why they are called as fundamental rights. They are mentioned or enumerated in the fundamental law of the land, that is nothing but the constitution, so that is why they are called as the fundamental right. That is the first reason. And the second reason is they are justiciable in nature. Justiciable in nature means in case of the violation of the fundamental rights, then the aggrieved person can move to the court for his rights. The courts are responsible for the implementation of the fundamental rights. In other words, judiciary act as a watchdog of the fundamental rights. In case of the violation, the aggrieved person can move to the court. So that is why they are called as the fundamental rights. Now let us try to understand the features of the fundamental rights. What are the various features of fundamental rights? First one, they are not absolute. That means they are subjected to the suspension of rights. during the operation of national emergency under Article 352, the rights guaranteed under Article 19 suspended, automatically suspended. It also, Article 352 not only suspends Article 19, it also suspends Article 32 also, which means during the suspension of the fundamental rights, a person cannot move to the court for his rights under Article 32. Article 32 provides a constitutional remedies for the fundamental rights. Under Article 32, an aggrieved person can move to the court for the enforcement of his right. But whenever the fundamental rights are suspended during the operation of national emergency, he cannot move to the court. That is also Article 32 also suspended. This is the first feature. They are in suspension of fundamental rights. And second feature is citizens alone enjoy fundamental rights. Citizens alone fundamental rights. Another important feature of the fundamental rights is some of them only guaranteed to the citizens of India. In other words, some of the rights enjoyed only by Indian citizens. No other alien citizens cannot enjoy the fundamental rights. But at the same time, there are some rights like right to life, right to religion, and right to against exploitation. These rights can be enjoyed by citizens of India as well as the aliens. Here, the Constitution aptly draw the distinction between the citizens of India and alien citizens in the matters relating to the enjoyment of the fundamental rights. That is the second feature. And third feature is they are restricted in nature, which means the fundamental rights are not absolute, and the courts can and the state can impose some reasonable restrictions over the fundamental rights of the citizens. That is the third feature. They are restricted in nature. And fourth feature is justiciable. They are justiciable, which means during the violation of the fundamental rights, a person can move to the court for the enforcement of his rights. So these are the few features of the fundamental rights. Now let us try to understand the sources of the fundamental rights and various fundamental rights enumerated in the Indian Constitution. The concept of the fundamental rights, prior to that, in the world, the first written document relating the fundamental rights is known as Magna Carta. Magna Carta which means list of rights. In the 16th century, the British king granted some rights to the England citizens. So that is in the form of Magna Carta. Magna Carta is considered as a first written document in the world regarding the fundamental rights, and this is one of the important one of the important point we need to remember in the examination point of view. Which questions can be asked like this: which one of the following is considered as a first written document regarding the fundamental rights in the world? So that is Magna Carta. And after that, these rights enumerated in the American Constitution in the form of Bill of Rights. The form of Bill of Rights, American Constitution kept fundamental rights in its Constitution in the form of the Bill of Rights. The framers of our Constitution were taken or borrowed the feature of the fundamental rights from the American Constitution. Here again we need to remember this one is the important point in the examination point of view. Fundamental rights were taken from American Constitution. Taken from the American Constitution, and they kept in the Indian Constitution in Part 3, under articles 12 to 35, part 3 and article 12 to article 35 of the Indian Constitution deals with the fundamental rights. Here the Constitution itself classifies the fundamental rights into the 7 groups, namely this classification was made or done by the Constitution itself only, not by ourselves. The Constitution itself classifies the fundamental rights into the 7 groups, namely first one, 14 to article 18, right to equality. Second one, article 19 to article 22, right to freedom. Third one, article 23-24, right to against exploitation. Fourth one, article 25 to 28, right to religious freedom. Fifth one, (29-30), cultural and educational rights. Cultural and educational rights. Sixth one, article 31, right to acquire and dispose property. Right to property. Seventh one, article 32, right to constitutional remedies. So these are the rights guaranteed by the Constitution, and the Constitution classifies them into a 7 groups, namely article 14 to 18, right to equality, 19 to 22, right to freedom, and 23-24, right to against exploitation, 25 to 28, right to religious freedom, and 29-30, cultural and educational rights, 31, right to acquire and dispose property, 32, right to constitutional remedies. But today we have only 6 fundamental rights. These are 7 rights were enumerated till 1978, but today we have only 6 fundamental rights. Why? Because by 44th Constitutional Amendment Act 1978, 44th Constitutional Amendment Act 1978, enacted by the Janata government under the leadership of the Morarji Desai, and this 44th Amendment Act 1978 eliminated the right to property from the list of the fundamental rights. As of now, today we have only 6 fundamental rights. Because of this 40, this is one of the important bit we need to remember in the examination point of view. Right to property was deleted by which one of the following Amendment Act? That is 44th Amendment Act. And question can be asked like this also: which one of the following right was ceased to be operate as a fundamental right? That is right to property. So because of the 44th Amendment Act, right to property was deleted from the list of the fundamental rights. As a result, today we have only 6 fundamental rights in the Indian Constitution. Now, what is Article 12? Already we know that fundamental rights are starts from Article 12 to Article 35, but right here, right, we wrote only Article 14 to 18. But what about Article 12 and Article 13? Now we are going to understand what is Article 12 and Article 13. First one, what Article 12? Definition of state. Here again, recall, state means government. Here Article 12 defines what is meant by government. Accordingly, state includes, first one, union, executive and legislature, union executive and union legislature, that means central government and parliament. And second one, state executive and legislature, and third one, local bodies, and fourth one, LIC, RBI, SAIL, GAIL. These are also comes under the definition of the state under Article 12. Along with these, any private organization or a private body which was financed partly or completely by any of the above state, that also comes under the definition of the state under Article 12. But here what we need to remember is judiciary is not comes under the definition of the state under Article 12. In many examinations, question were asked like this: which one of the following is not comes under the definition of the state under Article 12? So judiciary is not comes under the definition of state under Article 12. This is one of the important point in the examination point of view. Judiciary is not comes under the definition of the state under Article 12. Now, what is Article 13? Doctrine of eclipse. Which Article 13 says that whatever the pre-constitutional laws, whatever the laws enacted before the commencement of Indian Constitution. Why? Because India attains independence in the era of 1947, but Constitution came into force from 1950. So whatever the laws passed in between these years, if those laws against to the fundamental rights, those laws cannot be enforceable. In other words, those laws cease to be operate. That is doctrine of eclipse. Provided only those laws which are in the nature of against to the fundamental rights. Indirectly, Article 13 empowers the judiciary to the judicial review. That is Article 13, doctrine of eclipse. Once we recall what is meant by doctrine of eclipse, doctrine of eclipse means whatever the pre-constitutional laws which are against to the, which are in the nature of against to the fundamental rights, those laws will not be enforceable and those laws will not be implemented, or those laws cease to be operate. That is Article 13, doctrine of eclipse. Now we are going to understand the various rights, that is from Article 14. Already we know that Article 14 to Article 18, right to equality. Now Article 14. Article 14 has two parts. One is equality before law, and equal protection of law. This is Article 14. equality before law and equal protection of law. Now let us try to understand what is meant by equality before law. The concept of equality before law is an England origin and which are similar to the concept of the rule of law. Rule of law which was proposed by A.V. Dicey, a English constitutional expert. A.V. Dicey proposed the concept of rule of law. Here again this is the important point we need to remember. Who proposed the concept of rule of law? Rule of law was proposed by A.V. Dicey, which means no person is above the law. All should be treated equally in front of law. There shall not be any special privileges to anybody. But here there are some exceptions to this general rule, equality before law, in India as well as in England also. In England, British Queen enjoy the immunity from this general rule. In India, President of India and governors of the states and civil servants and for ambassadors, they all enjoy the immunity, which means it doesn't mean that they enjoy the immunity. It doesn't mean that they can do anything. It means there shall not be any civil proceedings initiated against themselves as long as are during their office. That is equality of before law. And now let us come to equal protection of law. This is American origin. Equal protection of law is the American origin, which means law should be equally applied among the equals. For identifying the equals, we can classify the society into women, children, disabled, and old age people. So this is the reasonable classification for the purpose of identifying the equals. The society can be reasonably classified. Article 14 supports for the reasonable classification. Equality or equal protection of law means law should be equally applied among the equals. Say for example, take women. These are equal category. Among the women, law should be equally applied. There should not be a separate law for the rich women and poor women and upper caste women and lower caste women. As long as the women concerned, law should be equally applied. As long as the children's concerned, law should be equally applied. But there may be difference in the application of the law between women and children. Why? Because these two are not equals. These two are unequals. Law can be unequally applies among the unequals, but as long as the equal concern, say for example women or children or disabled or old age, as long as the equal concern, law should be equally applied. There shall not be any separate law. Here what we can inference is Article 14 prohibits class legislation. This is one of the important point. Article 14 prohibits class legislation. Class legislation means making of laws based on the caste, that is class legislation. Article 14 does not provides or does not support the class legislation, but at the same time Article 14 does not prohibits reasonable classification. It provides, it supports the reasonable classifications, that is Article 14. Now Article 15. Prohibition of discrimination. Prohibition of discrimination. Article 15 says that no person shall be discriminated on the grounds of his caste, creed. Here creed means religion, gender, color, place of birth, race, etc., etc. Article 15 says that no person shall be discriminated on the grounds of his caste, creed, gender, color, race, place of birth, etc. But at the same time, there are some exceptions to this general rule. Let us look at the various exceptions to this Article 15. But whereas Article 15 says that there shall not be discrimination on the grounds of gender, but at the same time, this is exception. Exceptions to Article 15. Though Article 15 says that there shall not be discrimination on the grounds of gender, but at the same time, Article 15 Clause 3 empowers the state to make a special provisions in favor of women and children. State can make special provisions in favor of women and children. This is one of the important article we need to remember in the examination point of view. State can make a special provisions to women and children under which one of the following articles? That is Article 15 Clause 3. Now, again Article 15 says that there shall not be discrimination on the grounds of the caste, but Article 15 Clause 4 empowers the state to make a special provisions in favor of socially and educationally backward classes and scheduled caste and scheduled tribes. Seats can be reserved in favor of this community of the society in the educational institutions. And this Article 15(4) was added by First Constitutional Amendment Act 1951. Article 15 Clause 4 was added by First Constitutional Amendment Act 1951. And Article 15 Clause 5 it empowers the state to make a reservations of seats in the educational institutions, including private education institutions, in favor of scheduled caste and scheduled tribes and other backward sections of the society. Reservation of seats in private education institutions. That is Article 15 Clause 5. This Article 15 Clause 5 was added by 93rd Amendment Act 2005. This was added by 93rd Constitutional Amendment Act 2005. So these are the various exceptions to Article 15. Now Article 16. Equality of opportunities in public employment. Here public employment means government jobs. Equality of opportunities in public employment. That means no person shall be denied his opportunities in public employment, again on the grounds of caste, creed, gender, color, place of birth, race, whatever it is, etc., etc. No person shall be discriminated and shall be denied his employment opportunities on those grounds. But at the same time, there are some exceptions to this Article 16 also. Let us see what are the various exceptions to this Article 16. Exceptions. Though Article 16 says that no person shall deny his opportunities on the grounds of his caste, but here Article 16(4) 16 clause 4 empowers the state to make reservations of some government jobs in favor of scheduled caste and scheduled tribes and other backward classes if there is no sufficient representation from this community. Article 16(4) empowers the state to make a reservation of some posts in favor of this section. That is the first exception. And the second exception is Article 16(4)(a). Article 16 provides the reservations in jobs, but Article 16(4)(a) provides the reservations in promotions. Reservations in promotions. And this Article 16(4)(a) was added by 77th Constitutional Amendment Act 1995. Added by 77th Constitutional Amendment Act 1995. So this is one of the exception to Article 16. And third exception, 16(4) clause B. The general rule of Article 16, that is, no person shall deny his opportunities of employment on the grounds of caste, that is Article 16 general rule. The general rule of Article 16 need not to be followed while recruiting the backlog vacancies. While recruiting the backlog vacancies, the general rule of Article 16 need not to be followed. That was stated by the Article 16(4) clause B. And this Article 16 clause 4B was added by 81st Constitutional Amendment Act 2000. So these are the various exceptions to Article 16. Now Article 17. Prohibition of untouchability. This is the direct question in the examination point of view. Which article prohibits the untouchability? Prohibition of untouchability. In order to implement the Article 17, the Government of India has enacted Protection of Civil Rights Act of 1995. To implement this Article 17, Government of India enacted Protection of Civil Rights Act. (1995). Now Article 18. Abolition of titles. During the British Raj system, the British government awarded some titles to the persons, those who are very loyal to them. But those titles like Maharaj, Diwan, Rajbang, etc. These titles were abolished by Article 18. But at the same time, Article 18 permits to wear certain types of titles, like if those titles relating to our educational qualifications, say for example professor, doctor. These titles can be wear. At the same time, titles belongs to your services to the nation. Say for example like Paramavir Chakra, Ashok Chakra. For your services to the nation, those titles also can be permitted. Except these two titles, rest of all titles were abolished by Article 18. Now let us have a overview about Article 14 to Article 18. That is right to equality. All these articles were aimed to remove the inequalities in the society. So that is why Article 14 to Article 18 is known as right to equality. Now Article 19 to 22, right to freedom. In many examinations, questions were being asked like this: which one of the following articles deals with the right to freedom? That is, Article 19 to Article 22 deals with the right to freedom. Let us try to understand Article 19. There are set of freedoms guaranteed under Article 19. Say, for example, Article 19(1)(a) or Article 19(1)(a). We can use any of, because in many standard books there are the one and some books use it (a). Article 19(1). Freedom of speech and expression. That is first right guaranteed under Article 19. 1(b). Freedom or right to assemble in a peaceful manner, which means without carrying the weapons or arms, without carrying the arms, the people can assemble in a peaceful manner.